why does it matter?
Or why does it matter? Why is it important? What's the rationale? It's just different language.
Okay. Uh, um, I can't say I've read, but I think of the top, I would say it helps to because of the effects of oil and gas.
Okay, I'm not too sure what you are saying, but because I'm
Can you hear
having
me?
yeah, yes, but it's kind of blood. I'm sure your classmates too were struggling to.
Can I send it to
I'm sorry.
Can I send it to the chat box if you can't hear me
Yeah, please
well?
do, please do, please do. Okay, let's move on. Although don't I'm trying to do several things at once, and I'm in the middle of ice. I'm so cold. Um, so why is it important that international law is that oil and gas inhabitants would establish a framework to balance the sovereign rights the states will have to resource exploitation as well as its obligation, maybe, for instance, to protect the environment. So states have an obligation, though international law gives them the right to explore and exploit for minerals, it also gives them the obligation to protect the marine environment. So you have your rights and you have an obligation coexisting side by side. I'm just talking about this generally, and then when we go into the details of the Geneva Convention and UNCLOS, you'll be able to see it a bit better and you'll be able to contact me. I think I want to give you an article on what's it called? Ownership. That's for later though. I don't have, as I said, I don't have my information with me. I'm having problems with a lot of problems. Okay. So I'm trying to contend with so many different factors. That's why I'm a bit upset that you guys don't understand the nature of sacrifice in order to do your work. Hmm? Maybe you think it's the big money I'm being paid. Okay. So that definition, this issue of rights to explore, exploit, as well as obligation to protect the environment, of course, has an impact or has implications. So when you have an environmental issues with environmental protection or mitigation, so when you are producing oil and gas, you must mitigate the impact on the environment. So I told you that this first semester of petroleum and energy will deal mostly with oil and gas. And then the next semester we'll do more other wider energy and electricity work. And the definition basically triggers where you are in the environment, where you are in the ocean or offshore has has different legal regimes involved or potentially different regimes involved. So when you have your national law, for instance, you're going to have requirements such as environmental impact assessment and so forth, because international law requires you to protect the environment. So because international law requires you to protect the environment, you have to have EIAs and you have to do measures to avoid and minimize adverse effects on sensitive marine environments. And one of these things you have to do, you have to employ the best technology. You have to do best available technology. You have to do what we call good oil field practice. Good oil field practice. So if international law does not say what we should do, then national law will not react appropriately, especially when we're talking about rich biodiversity. Look, the Niger Delta area is one of the most biologically diverse areas in the entire world. It's a very important ecosystem for the entire world, not just for Nigeria. Okay, so don't think that what's happening there doesn't concern the world. It concerns the entire world, not just Nigeria. Now, so what are the obligations that um, states have to undertake? Well, because you have defined these habitats, you have to have standards. States have to meet standards. They have to prevent uh, significant marine harm. Because don't forget, as I said in the first class, the marine damage or harm you cause will not be just to your own country, but to the wider environmental ecosystem. So if I pour off 1 million barrels of crude oil offshore Nigeria in the Atlantic Ocean, it's not going to stop in Nigeria. I don't think pollution respects boundaries. It's going to keep moving. The wind and the waves and the ocean currents will move it to other countries to kill off plants marine plants as it's going, to kill off marine mammals or animals as it's going, to kill off the fish, to kill off everything, to pollute everything, and to make it toxic. Yeah? Are we together? When I say are you together, is that
Yes,
maybe
sir.
you have somebody that can. So I don't want to find that
Yes, sir.
maybe there's nobody in class or nobody hears what I'm saying. And then if we now say when a state fails to do its work under international law, then the issue of responsibility, it has responsibilities under international law, and that's very important. Yeah, okay. Oh, don't you can do your thing though. Good morning. So we look at also the issues of regulatory certainty for the industry. We're looking at the fact that investors want to know where they are standing. Oil and gas operators want to know where they are standing. Where I locate my platform, I must know what laws apply to me. Is it just Nigerian law? Is it international law? What laws apply to me? I'm able to evaluate those laws to estimate my regulatory risk. I have to plan my operations to be compliant with environmental standards, and I have to budget for um, environmental mitigation measures in case a pipeline bursts or whatever. I have to have measures in place to attack it immediately. Also, I have to deal with decommissioning measures. When I talk about decommissioning, I think I discussed decommissioning um, in our first class. And can Tovi Shede and Beniza tell me what decommissioning is? Tuvishede. If I didn't pronounce it well, please do help me with it. But I think you know who you are. Tuvishede Ebenezer. Tuvi, you're not in class. Okasi Chizom. Okazi Chizom. Class rep, make a note of anybody that is not in class. Okay. Okazi Chizom, are you in class? Some people don't even have names, they just have magic numbers. So why can't you speak to Vishede? Because you're in the wrong place, Abi.
Hello, sir.
Hello, yes. How come I can't hear your voice? What's up now?
I think it was my earpiece that prevented me from
Okay,
speaking.
okay. There's always one excuse. Thank you for coming, Sha. So what was my question? But I've forgotten my question.
I think your question has to do with
Mhm.
decommissioning. I think you
Exactly.
mentioned
So what is decommissioning? I think I said it in the previous class. What's decommissioning? What is it about?
I think decommissioning should border on like maybe existing bodies or existing bodies for
Okay.
maybe the regulation of um petroleum and natural energy in the country, or even within the international bodies, um like
Sheifumi's iPhone. Help Tovishede. Sheifumi's iPhone. Help Tovishede. Madam iPhone or Mr. iPhone, are you one of us? No. Eyo Benita Oluwa Koinsola. Eyo Benita Konyisola. Are you in
Yeah.
class?
Yes, sir.
Who is speaking?
Eyo Bernita.
Okay, welcome.
Yes, sir. Thank you, sir.
So I think you should kindly help to fish a day.
Yes, sir. I just joined, but I think I know the question. That is, what is decommissioning,
Yeah.
sir? I think decommissioning means when probably the people involved in a project in oil and gas,
Mm-hmm.
when they remove all the things that they used, or probably dismantle the facilities. And I don't know whether it's for safety or something, but sir, that's all I know for now.
Okay. Well, if you are not new to my class, I told you guys in my first class that I'm a global expert in the field of decommissioning. I'm a global expert. So you don't even know what your lecturer, your professor specializes in. I'm one of the leading experts in the whole world on this topic. Hmm? So when you go for interview with Shell and they ask you a simple question like that, it could be what means the difference between getting a job or you think this one is not a serious student. They don't even know what their professor does.
Yes, sir.
I told you guys to go online to look at my book on decommissioning, but I didn't say you should go and buy it or but you not say that I asked them to buy $150 or whatever it is now. I can't remember 50 euros or I can't remember what it is. So please, you got it right because you know that it's the dismantling or the removal of infrastructure and equipment after field life. So I've used the equipment for many years now. For 20 years, I've been pumping crude oil. I've been moving crude oil. I've been moving gas. And when the gas has finished, I can't just leave. It's like littering, isn't it? I can't just leave it and walk away. I must do something and tidy up the environment. I must remove those structures. So I need to plug the wells, the hole in the ground, plug it deeply with cement so that it doesn't break out um, oil into the environment or gas or toxic chemicals. I clean up the pipelines, then remove them. I take them away, and then they dispose of them. So that's what we've been talking about. Are we good? I don't understand what you're saying. Can anyone tell me? Okay. If I don't hear, I assume you are all good and I move on. Okay. So that's where it is. We'll have the location of those platforms and all those equipment. We'll have the industry will need to know. They want to know where they're going to get their field. So if I build in deep water, what are the implications? If I build in shallow waters, what are the implications? Then the issue may also have um, connection with issues of liability and compensation frameworks. So the defining these habitats will provide a legal basis for establishing where liability lies and how do we get compensation, especially for oil spillage. Okay. Also, resource management is an issue that we should bear in mind and governance of the area because resource governance, management, and conservation of marine resources is very, very important under international law, especially in those areas that are beyond the national jurisdiction. There also, do you know there are areas where the International Seabed Authority regulates? They regulate the activities to protect seabed habitats. Now, if no country has any influence on it, then it's left to the International Seabed Authority. So we should bear that in mind. The International Seabed Authority as an institution that does its work protecting resource management and governance. Okay. So international law would tell us some things, and those things would be important for us to uh, environmentally manage our resources. And so we need to do a balance between economic development and sustainable management of marine ecosystems for present and future generations. So that business of sustainable development brings its head up. When you talk about sustainable development, you would you need to know what the Greenland report said about sustainable development. So I hope you're taking notes and you can go and write this down. Now, I was mentioning environmental protection and conservation. There are some areas that are very, very fragile and significant to the entire world. Nile Delta is one. The Amazon Basin is another one. And these are it's important that people don't just go there and scatter the whole place and then walk away. Okay. Are we good? I mentioned issues
Yes,
like
sir.
liability and compensation. There are mechanisms such as the International Convention on Civil Liability for Oil Pollution Damage. We have the International Oil Pollution Compensation Fund. We have different issues when we deal with where the habitat is. What about conflict resolution? I mentioned the fact that if I um, get a license to in an area offshore that is close or maybe within the borders of a neighboring country, there could be issues of conflict. There could be issues of conflict. And I said how the law has helped us to overcome that conflict. Okay. We have to have the activities of international bodies such as the International Maritime Organization. So why do we need to have legal definitions? We must know it because if you want to implement your commitment under international law, you, the states, must know what your obligations actually are. So the states have obligation under the UN Convention on the Law of the Sea, UNCLOS, and UNCLOS requires states to protect and preserve the marine environment, including rare or fragile ecosystems and the habitats of threatened or endangered species. That's why even onshore in developed countries, where you want to, if you want to, say, build a housing estate, then they find out that that's the place where some rare bird, that's where it nests. They will not give you permission. That bird will not allow you to begin the thing. Or the bird has chicks. They will say you should wait until those chicks are grown up enough to fly and leave the place before you go and take over the environment. Okay. How are we doing? Hmm?
Fine, sir.
Well, we are fine. We are happy. We know it all. Okay. I'm just gonna set my exam since you guys don't need me anymore. Wish you well. So if you look at some of the areas we're talking about the territorial sea, territorial waters, we're talking about the continental shelf, and it's very important that you know how these things are defined. The territorial waters or the territorial sea is the belt of coastal waters that extend up to 12 nautical miles, up to 12 nautical miles from your state's baseline. And it's this where the state exercises full sovereignty. You have full sovereignty if that's water is called your territorial waters or territorial sea, up to 12 nautical miles. Okay. Although you have full sovereignty, you can control who's coming and going there. If foreign vessels have the right of innocent passage, international law preserves that right of innocent passage. I will talk more about that, the right of innocent passage. Then the continental shelf is the seabed and subsoil. The seabed is that prolongation of your land territory into the water. I described all of this in my previous class. Prolongation of the land territory into the water, that landmass, with an outer limit of about 200 nautical miles from the baseline. And that's the place where the state has the sovereign right. State has sovereign rights. Sovereign rights. Those words are important. Not rights. State has rights. No, sovereign rights. When you say have sovereign rights to explore and exploit natural resources, it means that nobody, no other state, no other company, nobody else has the right to challenge my my dominance of the area. That's so always use those words carefully. Sovereign rights. Sovereign rights. So, as I said, um, territorial sea extends up to 12 nautical miles from your baseline, and who has jurisdiction over this area is the coastal state, is the one that has sovereignty. over its own sea, similar in many ways to its land territory. Although in this one, it cannot prevent rights of innocent passage. Okay, so foreign vessels, as I've said, have a right of innocent passage, meaning they can pass through the territorial sea as long as their passage is not prejudicial to peace, good order, or security of that coastal state. So long as they can meet that criteria that they are passing through innocently, then coastal state cannot prevent them. But they need to meet that criteria. The continental shelf, on the other hand, I said, look at definition. Definitions are available under international law. The seabed and subsoil of this. We're looking at the seabed and subsoil. Seabed, the bed of the sea, and under it, the submarine areas under the water that extend beyond the territorial sea. So it's the prolongation of the land mass. It considers the shelf, the slope, and the rise. What rights do we have here? As a coastal state, you have sovereign rights for the purpose of exploring and exploiting the natural resources, including on or beneath the seabed. So what the resources on top of the seabed or underneath the seabed, you have the rights to it. And this includes mineral and non-living resources, as well as living organisms belonging to sedentary species that are in place. When I say mineral resources, when I say non-living, when I say living resources, what do I mean by? Give me an example. There's no right or wrong answer. Just try. Who wants to volunteer? Nobody? No volunteer? 2106 1282. Are you alive and well? 1282 2106 1282. Where are you? Nobody? Okay. Make a note of that number, class rep. So I think I spoke about the sovereignty and your sovereign rights. And then should look carefully about how the international law defines these limits to this coastal states. Now, I think I've discussed the territorial sea and how it goes up to 12 nautical miles, how the state is sovereign over it. They're sovereign over the airspace. They're sovereign over the territorial sea. They're sovereign over the seabed, and underneath the seabed, that is the subsoil. So that extent of sovereignty, you should make a note of that. What are the limitations of this? I said that sovereignty is exercised subject to rules of international law, notably right of innocent passage for foreign vessels, which they are allowed to pass so long as their passage is not prejudicial to peace, good order, or security of the coastal state. Can anyone tell me why the rights of innocent passage is protected? Why does international law protect rights of innocent passage? Anyone? Why does international law protect the rights of
Good
innocent?
afternoon, sir.
Good afternoon.
Okay, so I think international law protects the right of innocent passage of foreign vessels because of, number one, trade and commercial interest, or commercial safety generally.
Okay.
If territorial waters form part of normal shipping routes, it is
Yes.
important
Right.
that those shipping routes are protected.
Exactly. Very good point. Excellent point. Well done. So there we go. It's not rocket science. We have to protect the rights of all states. Otherwise, you will stultify international trade. You will stultify development. When every state now puts a weapon on top of the water, or you have to be, you put toll gates on it and you have to be paying money as you're going. It will be completely senseless. Okay. And also for historical reasons, and I'll tell you those historical reasons. I just wanted to review continental shelves with you because I've told you about it, and told you how the continental shelf exists, just like the territorial sea. And the continental shelf is not just a legal concept or a legal feature, but it's a legally defined maritime zone. That's what's important. It's not just it's the legal definition that matters. The fact that it's a legally defined area, legally defined maritime zone. That's what's important. It's not just a mere geographical zone. It's a legally defined and protected area over which is legal. The coastal states will exercise sovereign rights for exploring and exploiting its natural resources. And I mentioned the fact that the legal continental shelf extends to the outer side of the continental margin or to a distance of 200 nautical miles from baselines, as where the continental margin does not extend to that. Can I urge you guys to go online and Google pictures and images of the continental shelf, so to give you a good idea of what we're talking about? Please do that. Okay. Now, there's an extended continental shelf. An extended continental shelf. If the natural prolongation of the land territory, that's the continental margin, that includes the shelf, the slope, and the rise, goes beyond that 200 nautical miles, the state can claim an additional or an extended continental shelf subject to certain geological and bathymetric criteria. There's some measurement things that will have to be done before you can claim those rights. These claims must be submitted to the Commission on the rights. These claims must be submitted to the Commission on the limits of the continental shelf for recommendations, which are final and binding. Okay, so you can claim the extra. You don't say you will get it, but you can claim it. Now, I'm asking the people whose names have been mentioned to go and do homework for me, to do me a one-pager that should cooperate together. Class rep will send it to me by the next class. If I don't get it by the next class, I will come after them to tell me why and how do states obtain an extended continental shelf? Why and how do states obtain an extended continental shelf? And part of the answer of what I want to see is Nigeria actually asking for one? Has Nigeria been given one? Have we asked for or been given? I don't know. You let me know that. Class rep, you have to give me this information and don't let me forget. It's your obligation to make sure I remember. Don't try to protect your so-called friends. Okay. So the rights that we have, the coastal states' rights over the continental shelf are what? Exclusive. The rights are what? Exclusive. What does that mean when I say the rights of the coastal state are exclusive? Who wants to make an attempt? Akinsulu Temitayo. Akinsulu Temitayo, are you here? Akinsulu. What about Oladi? Okay, not Oladokun Taiwo. Oladokun Taiwo, are you in class? Orobusa Igalo, are you in class?
Also,
Oladokun Taiwo is in class, okay? So what's the answer to the question?
um, you said the rights of coastal states are exclusive,
Yes,
and
what does that
I
mean?
think that means those rights are peculiar to the states.
Meaning what?
The rights are peculiar to the coastal states themselves and are not shared by other
States.
states.
So give me an example of how that can work. Just give me an example.
For example, let's say a particular state has the right to perform certain exploitations in a particular area. No other country can do the same.
Uh-huh. I'm listening.
Yes, sir, that's all I can say about it.
I didn't guess what you said though. What did you say? A particular state
I
has the
said,
right. Okay, if Nigeria has the right to produce crude oil 100 miles off the coast of Ondo State, then it means that the Republic of Benin or any neighboring state cannot interfere with that right and try to explore and exploit that area. That's all.
yes, sir.
So that's why I said you should say it. See, that you can remember that more when you practicalize it than if you just talk about it like that. Okay.
All
So
right,
the
sir.
coastal
Thank you, sir.
states rights over condensed shelves are exclusive. So it means also that if the state does not exploit the resources, another state cannot go there without its express consent to go and be exploring and exploiting it. It's not possible. It's exclusive to it. So this rights does not necessarily impact on um, the airspace over it. And let me go back to what I was going to say, which is um, if I asked you a question, um, I could ask you a question like um, trace or document or advise on the international development of the law of the sea. How did the law of sea evolve? It's a very important question that we should bear in mind. The development of the law of the sea. So the international law of the sea basically has evolved over centuries from a principle of freedom of the seas, which you have mentioned, freedom of the seas, to a comprehensive system, which is a rules-based system of the UNCLOS. What is UNCLOS? The UN Convention on the Law of the Sea. So the historical development timeline is an old, in the ancient times, we've had ancient early maritime rules such as the Rhodian Sea laws, which is around 900 before Christ, 900 BC, Roman law principles of the sea, commune omnium, common properties. You can see that that mentality has been there for a long time. Common property. Roman law talked about common property. The sea is common property. And this established the foundational approach and concepts of shared use and commercial regulation. Shared use, because it's common property. Medieval codes, you had Consulate of the Sea, look at other medieval codes that developed in Europe to manage trade and also to resolve disputes between seafarers. Now, the age of discovery, under the age of discovery, there had been quarrels between Spain and Portugal as to the ownership of vast ocean territories. So look at the Treaty of Tordesillas. So over the years, there had been all sorts of contentious rights and privileges over the seas. Now, in the 17th century, you have what um, a seminal work by the Dutch jurist Hugo Grotius. In 1609, Dutch jurist Hugo Grotius publishes Mare Librium, the free sea, the free sea, and argued that the sea cannot be owned and should therefore be open to all nations for navigation and trade. And that principle became a cornerstone of international customary law. So in 17th century, 1609, Dutch jurist Hugo Grotius publishes Mare Librium, the Free Sea, arguing that the sea could not be owned. The sea could not be owned. It's not for anybody or any particular nation and should be open to all nations for navigation and trade, a principle that became a cornerstone of international customary law. Now, when I say international customary law, why is that important? When we say international customary law, what advantage is it that that freedom of seas or free seas becomes a principle? Oladipo Precious, let me hear your voice.
Sure.
Go ahead.
So please, can you repeat the question?
Why would I repeat the questions to you? What are you even doing in class?
I was trying to catch up with writing what you were saying, so I didn't quite get the question.
Don't give me excuses. I don't like excuses. The meeting is being transcribed, and you guys get transcribed notes. So even if you miss something out, you get it eventually. I asked you a simple question. You don't know the answer. I say, why is it important that when free seas become part of customary international law? What does customary international law mean? Why is it important when you talk about customary international law? Are you just hearing the phrase for the first time? Hmm?
I feel like from my understanding generally, I feel like customary international law is basically laws that are not written, international laws that has to do with says that are not written down, and it has developed over time from consistent practice of states.
Okay, I think Oladipo Precious is very good at Googling, but still that's the answer. There's no problem. Or am I wrong? Is that from your head?
So I was not Googling, I was listening to you.
Okay.
Yes.
When the exam comes, all our secrets will come out, some of us. No problem. Okay, lovely. Yes, so Grotius Prissy, I'm talking about a jurist. Then you find that issues to do with the status of the seas did not die. And there was a need, especially in the early 20th century, need for standardized rules. And there are conferences by the League of Nations conference at The Hague, which failed to reach agreement, especially in relation to the maximum width of the territorial sea. Every state is hungrily trying to grab um, um, as much resources it can get. Your land resources are fixed. If you go to try to expand it, it means invading another country, causing wahala. But in the seas, they just so that's just like free land. Free what? Free land. And it's it's the reason why a lot of a lot of people, a lot of countries would come to. That's why there will be no. It's not easy to come to an agreement as to um, ownership of or the rights that you could gain um, offshore. Are we good? If we're not good, say we're not good though. Now, after the Second World War, in 1945, after the Second World War, the US President Harry Truman unilaterally issued proclamations. That's why it's known as the Truman Proclamation of 1945, that extended America's jurisdiction to the natural resources of its continental shelf. And as soon as he did this, other states started claiming vast amounts of the continental shelf. Everybody was now, that's where we saw a shift or a move towards extended national maritime claims. It was a big, big shift. So the Truman Proclamation heralded a new era where everybody wants to claim massive amounts uh, of the continental shelf. Okay. The proclamation claimed the seabed and the subsoil resources for the US. It did not say that the water above belongs to them. Okay, let's be clear. The water resources, water column above the seabed and subsoil continue to be available to free navigation. So even they, their unilateral acts, they did not, they did not uh, breach the fundamental free seas rule. Now, this unilateral action was driven mostly by their post-war needs and the technological advances that opened up those arenas for development. So why is the proclamation important? What are the key aspects of this proclamation? What the US claimed was jurisdiction and control over mineral resources on the continental shelf that is adjacent to its own coast, which included, of course, oil and gas deposits. That's why they were targeting it. The jurisdiction over resources is what they claimed. The proclamation explicitly, clearly, no unambiguously says that, look, we're not saying you cannot move, that this resource grab does not affect the right to free and unimpeded navigation on the high seas. So moving on the high seas above the continental shelf in a ship is not touched. So, but what did it impact on in relation to international law? It's a departure from existing international law, because here's an example of a state grabbing hold of territory of sea space for itself. Now other countries said, if US can do it, we too can do it. Go and look up the other countries that also made a similar grab for these resources. So when other countries made similar claims, some even larger than that of the Americans, this led to the development of international discussions because it was going to become very chaotic. And that's what led eventually to the 1958 UN uh, Convention on the Law of the Sea. Okay. How are we doing? How are we doing?
So honestly,
Honestly,
it's quite a lot right now. It is quite a lot.
it's a lot, but did you read ahead? As I told you, I said 1,000 times, before coming to this class, you have the course outline. Did you read ahead? Even if basically just to look at it, did you look ahead? No, because I'll be shocked if you had looked ahead or read ahead and you're struggling with this basic pretty basic stuff. It's not even, there's no real difficulty about it. I've told you the history of how I'm talking
Hi,
about
sir.
I'm sorry?
Good afternoon. Can you hear me, sir?
I can hear you, but I was talking. Let me finish my thoughts. And
Sorry, sir. Can you hear me, sir?
I can hear you.
Okay, sir. I wanted
Can you
to
let me finish my thoughts? Because I was talking when you interrupted, so you wait first. Hmm? I'll ask you to speak when I finish. What I'm trying to say to you is that the what is going on is extremely clear if you do any basic work. Even if you don't do any basic work, I think if you listen carefully, I've been clear to go step by step as to why do we go offshore, why, how is it controlled and how is it managed? How are the rules governing the offshore evolving from ancient times? So that's what we're talking about. It's very, very simple. If you have a specific question, ask your question, but I'll just refer you to looking at your books, which you already have. Okay. Now, what's the gentleman, what's your question, please?
Thank you, sir.
Yes, sir. Just, I just wanted to mention the fact that these particular topics,
Mhm.
I couldn't even find them in the Yinka Moribi textbook that you referred to us the
So
last time.
hold on a
So,
minute.
and
Hold on a minute, young like listen to me, young man. When you have a course outline, there are different
yes,
books
sir.
there. You cannot use, there's no single book that would address. I recommended the cheapest to you. So you don't say that I have an interest in squeezing you for money. I can't be part of that kind of racket. I recommended the book is 1,000 naira. How much is it? I have no financial benefit from it.
Yes, sir.
I am saying to you, you
Yes,
can
sir.
go to the library to consult books, can't you? If you don't want to buy them, you can go to the library and consult books. You can go
Yeah, we
online
can. Yes, sir.
and download articles. So don't say I recommended a book that did not satisfy all your needs. No book, not one single book in this program can satisfy all your needs, all of the needs. No, not one
Okay,
single
sir.
book. Even the newer books that are being published today will not satisfy all your needs. And I wanted you to have diverse opinion, diverse authors. Don't rely on any single author and say, "Oh, I know that if I read Professor Ayo this book, all will be well." No, that will be poor training. That will be poor training. Don't
Okay,
rely
sir.
on anybody's single book. I can't, don't rely on my book or anybody's book. Rely on a variety of information. That's how a good lawyer is developed. I think you understand what I'm saying, don't you?
Okay, sir.
Thank you very much.
Yes, I do, sir. I
So,
do,
so
sir.
how did you
Thank you,
cope?
sir.
When you did not see it in Amoribe's book, did you just fall asleep on your bed and start crying? Or did you do something? What did you do? When you found Omoribe's, that small Omoribe did not give you the information you
No,
needed. What did you now do?
sir, I didn't.
You didn't do anything. Hmm? Who trained by
Well, I made further search
what?
online. I searched for articles on Google Scholar. But is
Mm-hmm.
hello, sir.
I'm listening to you. Go ahead.
Hello, sir. Can you hear me, sir?
I can hear you. Continue.
Okay, sir. I said that when I couldn't find it. Yes,
Mm-hmm.
when I articles and all, but it's just that most of the things that I seen in the class, some of them I couldn't even, like, I didn't even come across them in all the sources
Okay, what did I
that I
say in class
resorted
that
to.
what did I say
So
in class that from Magic Land? What did I say in class? Tell me what I said. Was there any specific thing you were looking for?
on
Uh-huh. Go ahead.
well, like what I just wanted to like from all your classes so far, you have mentioned the Truman's Declaration
Uh,
and what bet the
Proclamation.
1958 Convention, and yes,
Mm-hmm.
sir.
Mm-hmm.
So some of these facts that you have mentioned so far,
Yeah.
some of them were not
I said that's why I said to you that no single book will satisfy your needs. But now that I've told you about Truman Proclamation, if you Google Truman Proclamation, will you not see it? Hmm? If you Google Truman Proclamation of 1945, will you not see it? You will see it. I told you that when you started this course, I'm a deep expert in this area, and I will tell you
Yes, sir.
things that you will not find everywhere. So what do you want me to do? I can't cut my brain and hand it over to you.
Yes, sir.
Mhm.
Yes, sir.
Okay,
Yes,
don't
sir.
worry. Don't worry, you'll be fine, eh? Don't worry. Just take it
Okay,
easy.
sir.
All right. So.
Okay, sir. Okay, sir. Thank you, sir.
Okay, so where are we now? What was I talking about? Hmm? Okay, I was mentioning, I think I was talking about the Geneva Convention, how the fact that after all that kerfuffle as a result of the Truman Proclamation, and other countries also trying to find or take over pieces of land, pieces of their own territorial waters and their own continental shelf. Then we went to the Geneva Convention on clause 1, and the United Nations held its first conference on the law of the sea in 1958, which actually resulted in four separate conventions that codified existing customary law. That's what they tried to do. They codified customary law so that there'll be no argument, but left key issues such as the exact breadth of the territorial sea unresolved. So you see, there's a convention on the territorial sea and contiguous zone. So after the contiguous zone is after the territorial sea, contiguous zone, the continuous zone, that kind of thing. Convention on the continental shelf, I've told you that that's the land mass proclaiming into the sea. Convention on the high seas, convention on fishing and conservation of living resources of the high seas. Don't forget that I said that when we had, okay, I don't want to go to UNCLOS yet. So in 1960, you had UNCLOS 2. That second conference was held, but it failed to produce further results. So you see what I'm saying? How people come together and they fail to get results because of the contention and the self-interest that they're driving. International law on this area is complicated because you have to get not only self-interest, but common interest and balance it. You must get self-interest, common interest, and balance it. These are things you not see in books. I'm giving you insights. I'm here for insights. That's why I wanted you to read ahead so that you didn't uh, flounder at the early stages. Now, if you come to the more recent era, when we're talking about um, UNCLOS 3, UN Convention Law of the Sea, UNCLOS 3, that's the one, is the key one. It took negotiations between 1973 and 1982 to get to UNCLOS 3. That's what? 9 years of talking. Nine. Count it. Of diplomats meeting, cutting deals, blah, 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 compromise, hardline. 9 years of talking. So the third UN conference convened revolutionary efforts, really, involving over 150 countries to create a single comprehensive treaty. They wanted to create a single comprehensive treaty. And it was very successful in many ways. Key of the things, some of the things included the common heritage of mankind concept for deep sea resources. So deep sea-based resources, common heritage of mankind. That resource is not owned by any particular state, but owned by the entirety of mankind. Was proposed by Ambassador Arvid Pardo of Malta and the developing countries' concerns about access to resources um, offshore. Okay, so the UN Convention on the Law of the Sea was adopted in Jamaica, Montego Bay, and it basically establishes a comprehensive legal framework for all ocean areas and uses. In fact, it created new zones, some of which I've spoken about in the previous class, such as the Exclusive Economic Zone, EEZ. And it created institutions such as the International Seabed Authority and the International Tribunal for the Law of the Sea. That's how important this UNCLOS 3 is. Very, 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 very important. And UNCLOS 3 entered into force in 1994. So took 9 years to negotiate, entered into force How many more years after that? I don't know how to count. Who wants to help me? How many years did it take before entering into force? Adopted in 82, entered in force 94. How many years is that? Hmm? Look at all my students. None of them know maths, basic maths. No wonder your educational minister does not want you guys to do maths anymore. I'm very worried about you guys though. No maths. How many so how many years are we talking about? Eh? How many years?
12 years. 12 years.
So we're talking about 12 years.
12 years. Wow. Such a complex complex thinking, eh? I'm worried. I'm very worried. Anyway, it's 12 years. Now, UNCLOS entered the force in 1994, November 16th, 1 year after the 60th ratifications. 1 year after the 60th ratification, and is now accepted by everyone as the Constitution of the Oceans. It's very, very well accepted. It's a beautiful, um, um, beautiful treaty. Okay, can you imagine how hardworking those diplomats are to have come to that level? The other ongoing newer developments or newer agreements, some of which are not even in force, trying to expand upon the original UNCLOS framework to address some modern challenges on fisheries and what have you. So I'll let you to go and look into that by yourself. I always tell you that I don't tell you all the answers. I will probably tell you a few unique things. I'll also tell you 70% at least of what you need to know. So the people that are doing very well at and not those who can just remember and return it back to sender are the people who do research work. That's why I asked him when you could not see it in the baby book you have, that book will not have cannot contain your entire course. I even told you that it's an old book and it's outdated, way outdated, you know. But you can't expect answers from all these things. You are meant to go to the library. You are meant to look at different authors. You are meant to get a notebook and take notes from different authors and synthesize it together. You're not meant to just hear my voice and go to sleep. And you're not meant to take one book, no matter what the book, who the publisher is, including myself, and say this book is the Bible and all is well from the book. Are we together? Are we good? No? We're not good. Will it be helpful if we ended the class now, or so you can go and it seems this class is tougher than I thought it was, but what do I know? Hmm? Talk now. Who's your representative? I want to hear your voices.
So no, we can continue.
Okay, you're not so tired, you're not so emotionally drained that you have to collapse.
Not yet, sir.
Not yet. God bless you. So you should eat better, you should eat good food, you'll be fine. Hmm? Okay. So let me say something about, I think I was talking about UNCLOS 3. Because in the next class, we're going to move fast, as I told you. I may not be able to take all your classes. It's been extraordinary. I've been taking this as an extraordinary measure of my part. Um, um, to get to where we are at the moment. So I'm just trying to see if I can find the course outline so that I know what I'm saying, and I know you all have the course outline. Hello, hello.
Yes, we do. We have the course outline.
Okay, what's in the course outline? Read it out to me.
Okay.
Please.
So now,
Yes.
the third one is ownership of mineral resources, the nature and types of
No,
concessions.
we have not
Then
finished. So you think we are finished with number two? I'm not finished now.
okay.
I'm not
So
finished.
number two, that's the
Well,
legal definition of the habitat of oil and
yes.
gas. Then the
Yes,
continental shelf,
we need to
Antarctica.
go. We need to go more in depth to uh what Geneva Convention. You're supposed to have the convention. I thought you guys, if you had read this now and you see a law, you go and download that law. If you see a treaty, you go and download that treaty. Has anyone downloaded the Geneva Convention 58 or UNCLOS 82? Anybody? Okay, I won't hold you to account, but now I've told you that I want you to download it. But in the meantime, I would talk about that issue of the negotiation of UNCLOS 3. And I said it was a monumental negotiation that resulted in a comprehensive uh, uh, document that governs the seas. And the process, as I said, involved reconciling deeply conflicting interests between developed and developing countries. So it was a big battle between, on one hand, to tell you why it took so long to negotiate out, the conflict between the developed and developing countries, and also between coastal states and landlocked states. Coastal states and what? Landlocked states. Do you remember me talking about landlocked states?
Yes, sir.
So those landlocked states that show, say, so because we have no access to water, we're going to be left behind. So they became a nuisance, as they say. They also fought. Um, they also fought, um, for their own rights. So do you think landlocked states have a right to access the sea and get the benefits of the of the um of the convention? Do you think they should? Because they have no rights to the sea. They're not close to the sea. There are other countries between them and the sea. Do they have any rights?
I think so.
You think so, and you think right, because landlocked countries have transit rights and rights to access the sea under UNCLOS. So they have a right, landlocked states shall have the right of access to and from the sea for the purpose of exercising rights provided under this convention, including those relating to freedom of these high seas and the common heritage of mankind. So they've not been cut out or shut out completely, because their fear was that you just want to all share what is there and then there'll be nothing left for us. But that's all the kind of problems we had. Developed versus developing world, coastal versus landlocked states. And so there was a package deal or a consensus approach that resulted in what we now have. So I always think that these backgrounds are very useful so that when we think about it, when you're reading the provisions, it makes more sense to you. Good.
Yes, sir.
Also, as I've said, the UNCLOS negotiations were driven by technological advances because new technologies had arisen that allowed access to deep seabed mining and deep water fishing. It now became an issue of how can the existing law did not address or contain what was now coming up. So we needed a new law to do this. Also, we should note that decolonization and new countries had come on board, and these newly independent countries that are now in play that were not even able to participate in 1958 Geneva Convention. As you know, Nigeria was not independent in 1958. So these new players wanted a more equitable ocean order. They were arguing against the traditional freedom of the seas that benefited the traditional maritime powers. It's in the interest of America, UK, Netherlands, and those countries that have massive navies to say, massive fleets to say, well, we want freedom of the seas to we can drive on the sea anywhere we want to go. But those countries say, look, yeah, we don't necessarily want to stop you, but we also want to get our own rights or what we can do with the sea. And so the fact that since that unilateral Truman Proclamation, there had been unilateral claims by some states for a 200 nautical mile economic zone, which would expand national jurisdiction. And this was taken on board in the UNCLOS because to harmonize and provide a standard international practice. So that was very, very important. So the contentious areas, some of the things that we they fought to finish it over are maritime zones, defining the limits and rights within the new zones, such as the 12 nautical mile territorial sea and the 200 nautical mile exclusive economic zone was the battleground. But that's what resulted in the end, the massive negotiations and battles over it. The issues of this deep sea bed mining in parts 11 was very, very contentious. Deep sea bed mining. You can say when we are talking about oil and gas, we're talking also about mining of resources, the ability to mine for resources, not just oil and gas, but also other mineral resources that are there. And this was very contentious because a group of 77 developing countries championed the principle that the deep sea bed and its resources beyond national jurisdiction were a common heritage of mankind. They have a common heritage of mankind. So when we cut away all these our continental shelves, exclusive economic zone, there's parts of the oceans left that does not extend, that extends beyond all national boundaries or jurisdictions. They labeled it the common heritage of mankind. And they also that the ones who advocated for a common for international authority of the seabed to manage these resources and ensure equitable benefit sharing. And the US and other developed countries strongly resisted these things as overly state control and a threat to commercial mining interests. So they wanted it to be left open so that anyone can just go anywhere and start mining. But you can see that developing countries got their way in the end. Even the issues of navigation and transit became a negotiation issue because when you're talking about navigation, you have your traditional powers and those who don't have any ships at all. I don't even think Nigeria owns any ships now since our collapse of the Nigerian shipping line. So maritime powers, they prioritize unimpeded navigation. That is, nobody should stop us, especially going through straits, while coastal states sought greater control over foreign military and commercial vessels in their newly expanded zones. So maritime powers wanted to go where they want. Coastal states, especially developing countries, wanted greater control over foreign military and commercial vessels. Now, the contentious aspect of the marine environment and scientific research was that needs and that quarrel to balance environmental protection with the freedom of scientific research and economic exploitation. And that became an issue that had to be resolved. And also, as usual, many cases like this, dispute settlement was an issue. And that's why a mandatory system for resolving dispute conflicts was put in place, which led to the creation of the International Tribunal for the Law of the Sea. How are we doing? How are we doing? I'm going to round up the class soon. Since you guys are not, you have had enough, as they say. I want you to go and let that sink in you. You're almost at the end of the class. Go and drink water, go and rest. And I pray that you come back fighting. In the next class, I want you to, everybody, because I'm going to call people randomly to tell me the sections of the continental shelf, continental shelf, Geneva Convention on the continental shelf, and that of UNCLOS 82, the relevant sections you think are important when we are dealing with oil and gas exploration and exploitation. Is that okay? Homework for everybody. Is that okay? Nobody wants to talk.
Yes, sir.
Who says yes, sir? What's the name? Who says yes, sir? I want you to all come back with that information. I'm going to ask people at random. So class will put up this information on your group chat. everybody must have downloaded and looked at. Maybe I'll do a class, maybe I should do a test even. Don't doubt me. I can do a test and then you will now know whether you need to run away early or not. What are the sections to look at in the Geneva Convention of 1958 and the UNCLOS 1982? What are the relevant sections concerned with issues of natural resources, oil and gas, and or what have you?
Yes, sir. It's okay.
Okay. Is someone trying to ask a question? I can't hear. Are we good? Okay. Let me. So going on about how UNCLOS was working, what this conference tried to do, the dynamics of the negotiation session. I know I told you severally that there are several international conferences that failed and ended without reaching resolution. So what they did was a package deal approach. So the conference did not do the traditional voting until negotiations were completely exhausted. So instead, they adopted a package deal strategy where the trade-offs were made across different issues to achieve comprehensive consensus-based agreement that was acceptable to a broad range of states. And as you know, it took quite a while for all the states to start to accept it one by one. Took another 12 years. So consensus building, consensus decision making was the key driver for the success of UNCLOS 82 and its adoption and its future success. And right now, it is the Bible of the law of the oceans. And so after 9 years and 11 sessions, the convention was finally put to a vote of 130 in favor, 4 against, 17 abstaining in April 1982. The US, which voted against the convention primarily due to the deep seabed mining provisions in Article 11, did not become a party. But you can see that that has been overtaken by events. So the negotiation of UNCLOS 3 has now created a single universally recognized constitution for the oceans that provides the legal framework for nearly all maritime activities that take place in present times. So all the issues, the quarrels about the surrounding the deep seabed mining was later modified by 1994 implementation agreement to make the treaty more universally acceptable. So, any questions or comments as we're at the end of the class? No questions, no comments. We're all good.
Good afternoon, sir.
Good afternoon.
I did not hear the assignment. Like I wasn't able to catch all you said about the assignment. Can you come again on what the assignment?
You are always all very, very busy to write down things. I never.
No, I was typing it. You said sections of the UNCLOS and Geneva Convention relevant, but I did not get the
Yes,
after you said relevant.
relevant to oil and gas and natural resources.
Okay, thanks, sir.
Download the Geneva Convention 58 and UNCLOS 82. When you download it, go through it and choose and read all the relevant sections. I'm in the class. I'm going to ask you to choose to give me section. You take so the first relevant section, one person will give me. I'll ask another person for the second relevant section. So don't repeat what somebody has said. If you do that, you actually be penalized. Take it seriously. Okay? Take it very seriously because people are not coming to class on time. They're not taking the work seriously, and they're not able to justify the sacrifices I am making for you. So it takes two to tango. I'm sacrificing. I expect you to show some level of respect, or else I don't come to class and then we do it anyhow. But you meet your makers when it's time for exams anyway. Hmm? So if that's the only comment I have, any other questions, comments, no problems. Okay. I thank you all for coming, especially those who are early to class, very disciplined and decent. and I wish you all well. Have a wonderful day.
Thank you, sir.